Woo! You guys are excited for a Monday morning, right? Yeah, everybody's like already on turkey tryptophan, and it's not even Thursday yet. So I'm going to be presenting to you guys twice this morning. Both times are going to be interactive. Oh, no.
Oh, yeah.
Oh, yeah. Who said oh, yeah? Oh, yeah. What's your name?
Oh, no.
Oh, yeah. Oh, yeah. What's your name?
Jordan.
Jordan, where are you from, Jordan?
I'm originally from Pittsburgh.
Oh, originally from Pittsburgh. What office are you from?
Fifth Circuit Public Defender.
Fifth Circuit. Man, I hear you. All right, Jordan, right?
I'm trying to match the energy.
I can dig it. I can dig it. Yeah, again, there's two of these sessions. So, Jordan, you're going to be asked some questions every now and again. So keep that energy up while I'm talking.
Yes,
all right?
Yes, sir.
So today, guys, we're going to talk about client-centered representation. I will take absolutely no credit for this awesome PowerPoint. This is a presentation that's actually normally done by my boss, Grant Gibbons, the Circuit Public Defender for the 2nd Judicial Circuit. I am his lowly assistant public defender, but it's a joy to be here and to talk with you guys about client-centered representation for a number of reasons. Number one, I'm really passionate about it. I really care about the work that I do. I really care about the work product that I put out, and I really care about the people that I represent. Because there's no better job in this country as a lawyer than to have the opportunity to speak for someone who doesn't have a voice. To be a light for someone who is stuck in darkness, and to bring hope to someone who may find themselves in a rather hopeless situation. And all of that can be accomplished and done through client-centered representation. God bless you. Now, I know that Lawrence wanted me to touch on some things, and I'm going to do it right off the bat. Okay? How do you do client relationships? Right? How do you keep them good? Real simple. Return phone calls, guys. Ian, who's in the back. Hey, Ian. Ian works with me in the 2nd Circuit. Ian knows I have a rule in my office, which is I will return your phone call within 24 hours, with the exception of when I'm out of the office on vacation. I won't return your calls at all while I'm on vacation, okay? But if you call me and you're my client and you want to talk to me, I will return your call within 24 hours, always, unless I guess if I'm in trial, I won't return your call. But other than that, I will return your call. Now, if your mama or your daddy, I think we're going to talk about family dynamics here. You know, if mommy or daddy calls me, I give myself 48 to 72 hours because mama don't need to talk to me every day like my client does, okay? But the reality is the number one complaint of all lawyers, period, is what?
Communication.
You don't communicate with them. You don't communicate with them. Guys, if your freedom and your liberties are at stake, you would want somebody to talk to you on a relatively regular basis, right? I would, right? As a trained lawyer, don't raise your hand. As a trained lawyer, if you've ever been involved in a lawsuit, all right, you know, like, hey, I want answers now, right? You got family members maybe who passed away. You're dealing with probate. You're like, man, somebody give me some answers right now. You're a trained professional. These folks have no idea more often than not what's going on in the legal system, or their experience in the legal system has been terrible. Communicate with them regularly. Return their phone calls. Return their emails. Family dynamics. Get to know your client first. And if your client gives you express consent to talk to his family, get to know his family, his or her. So we're going to talk about express consent later in Defender Data, and I'm actually going to show you how to plug that into your file so that you and any lawyer, whoever comes after you, can know who you're allowed to talk to when you're managing a case. But once you've got express consent to talk to the family, do it. If you tell your client you're going to call their mama, call them. If you tell your client you're going to call their dad, call them. If you tell your client, hey, you know what, my client's cousin's my pal, that's the one I want you to talk to, call them, right? Because those are going to be the folks, when things get tough. You know, Alicia was talking earlier about, like, she was giving you some of her war stories with some bad charges, and, you know, it's like, oh, you can choose between time served and life without the possibility of parole. Well, you know what? It's going to be the family that you've kept in touch with. The family who loves their son or daughter. The family who wants them home for Thanksgiving this Thursday. who, at least said, don't tell your client you're an idiot. No, let mama do it. Mama will come and say, boy, you're acting like a fool. It's time to come home. Go get your time served, and we'll see you on Thursday. Right? So having those relationships, having an ability to communicate fluidly with family members is great. I'll tell you, I'm going to try not to do a ton of war stories, but I'll tell you one. I had a client who was charged with armed robbery, and for the life of him, he said, look, man, Bush, it was not me. I did not do this. That's not me on the video camera. It's definitely not my smiling mug while I'm smiling, punching that person in the face, stealing a PS5. Not me. All right. Kind of looks like you. I think it's you. You know what? Let me ask your mama. Bring mama in. We got this nice conference room. Thanks, Grant, on the camera. Thanks, Grant. We got this nice conference room. We got a big screen TV. I put that bad daddy in HD. And mama said, ooh, that's my boy. I said, hey, next time you talk to him on the phone, just tell him you watched the video. You don't got to tell him what you thought about it. Just tell him you watched the video. Say it in like the tone that mama does when mama knows what's up. Yeah, just do that. Case resolved. Guy got a good plea deal, resolved itself, right? And he finally was like, yeah, that was totes me. I wanted a PS5 for Christmas. Shouldn't have done it, right? All right. So, but having and knowing family dynamics is important. Now, it's not just for them to help you. It's also to actually know about your client's past. Sometimes you're going to have clients charged with really, really, really brutal, really difficult cases. And to understand their family dynamics for the trauma that they faced in those family dynamics or the pain that they've suffered as a result of those family dynamics will really help you as you're standing in front of a judge with a client who is charged with having sex with their own kids and saying, hey, yeah, this is really bad. This is really bad. But I need to tell you and humanize my client because the family dynamics where my client came from are terrible. And we're going to walk through that on Judge, how we got to this position, how these events led to mental illness, how these mental illnesses led to drug use, and so on and so forth. So understanding your client's family dynamics is really important. It can be a really powerful tool for you. It can also be a really powerful tool for your client in mitigation. Or it can also be a really, really difficult thing. Sometimes mamas are just difficult. They could come in and they can watch that video of their son robbing that dude point blank, smile on his face. I'm like, that ain't my boy. You got the wrong guy, Bush. Go to trial. We're ready, right? So sometimes it's difficult, and you just got to be able to deal with it and bear with it, and that's okay. But you know what? At the end of the day, if you include family, if your client wants them to be, you're building trust, okay? How many of y'all have been in private practice before or are in private practice right now? Yeah, you can raise your hands. It's great. Okay, so the folks who are in private practice know this, okay? I was in private practice before I became a public defender. You hear a lot of people talk about like attorney-client privilege, right? But Jordan, what's attorney-client privilege?
Everything you say to your client and you stays in that bubble.
That's right. That's a great synthesized version of that. I appreciate that. Do you know, Jordan, the privilege it is to be an attorney and have one?
Yes.
Yeah. Well, see, my folks in private practice know how hard it is to get clients, right? You're doing all this search engine optimization. Maybe you're like Sean Kent. You've got like 6 Facebook pages, 12 TikToks. You're looking like $1 million everywhere you go all the time, right? It's a real privilege to have a client, and as a public defender, they're assigned to you automatically, and that's a real privilege and a real gift. And you need to treat your relationship with your client that way. It is the reason why you have money to put food on your table. It is the reason why you have the ability to afford wherever it is that you live. If you have dogs or kids, it's the reason that you're able to do those things, and it needs to be treated that way. Grant really likes professional distance and respect. He avoids first names basically at all costs. I tell you, it just depends on the client. I've been doing this for a long time, so some of my clients who are like repeat offenders, and I've represented them for 10 years, I'll probably call them Gabe, Like, hey, Gabe, how you doing? What's up, man? You know, can't believe we're back here. How did this happen, right? But oftentimes, like when it's somebody that I'm meeting for the first time, I do use Mr. or Mrs. I try my best to sort of give them respect from the gate. Y'all may not have this problem. I do. I showed up to my very first murder client ever, and my murder client said, "Why did they send the law clerk?" I was like, whoa, hey, easy now. You know, he's like, come on, man, what are you, 20? I'm like, please tell my wife that. You know what I mean? Like, can I get this on recording? I'll play it later, you know? But sometimes, you know, just going in and having some respect and asking the same respect of your client, you guys are going to find, if you haven't had clients yet, sometimes client meetings can get a little contentious. Ooh, you laughing. What's your name? Logan knows about contentious client meetings already back there. Go ahead, Logan. Logan, what's an example of a contentious client meeting for you?
I'd rather plead the fifth on that one.
Man, here we are. I'll tell you about them. Contentious client meetings happen all the time. I had a client who, when I would see him, he would get real angry. Right? Not every time, but like every now and again, get real angry, start yelling and screaming and dog cussing and, you know, doing whatever. And, you know, hey, sometimes you just got to put them on timeout. Like, hey, buddy, I'm here to help you. I understand you're upset. We're going to stop this meeting right here. I'm going to come back in 2 weeks, and I'm going to see you then. All right? And next time, we're going to keep it calm. Ian sat in on a client meeting with me just last weekend, going the extra mile on after hours and weekend visits. Ian was with me at the jail. We had a trial that was scheduled to go to trial on Monday, and we were at the jail. And our client was going bananas about nothing to do with his case. Like VA conspiracies and all kinds of stuff. I mean, he was like all over it. Eventually, we were like, hey, man, just remember I'm on your team. We're working on your trial. We're ready. I'm going to go back to the office now and keep working on the trial. Like, I know this stuff's happening, that's great, but like we're going to go back to the office and we're going to get back to work on your trial. So, you know, sometimes it's even managing their expectations of the work that you're doing. Y'all will, I guess all of you already have clients, right? So in the Second Judicial Circuit, we have a rule, and our rule is if they are in jail, you will see them at least once every 30 days. Okay? That's a rule. If you got somebody who does not have the liberty and does not have the freedom to come and see you in your office, you should be going to see them. And that goes for private lawyers who are contract public defenders too. And I'll tell you why. You know, private lawyers who are contract public defenders do a great service to the circuit offices. A lot of folks who are down in the weeds in the public defender world don't realize like what a blessing it is to have contract lawyers. But when we have contract lawyers that don't go see their clients, that don't communicate with their people, it hurts everybody. Because then the clients are like, oh, public defenders don't come to see me. They don't want to talk to me. They don't do what I ask them to do, whatever. You need to go and see your clients. The number one way for a client relationship to fail is the fact that you don't visit them in the jail and you don't communicate with them. You know, I'm not saying go the extra mile every weekend. I'm not telling you to go do after-hours visits at the jail every day. I'm not telling you to go on weekend visits. I am telling you meet with the family. If your client gives you permission to meet with the family, kind of like I told y'all earlier, that's a big deal. Do it. All right, preliminary issues. We're going to do like, you know, we're going to keep this entertaining. Jordan. Yeah, Jordan, since you're matching the same energy. Jordan, you're going to be my client, okay? And so I'm showing up at the jail. This is our first meeting, okay? And Jordan, hey, so tell me a little bit about yourself, Jordan. Well, hold on, Jordan, hold on. Hey, Lawrence, what's up, man? How you doing? Yeah, hey, sorry, I'm at the jail with Jordan. Yeah, let me holler at you in a little bit. Oh, yeah, I can probably wrap this up in about 3 minutes. Yeah, I can meet you for lunch. No problem. All right, Jordan, go ahead, right? Don't do that, right? It should be so obvious. When you go, when you sit down and you're meeting with your client, be present. It's not that hard. If you have a briefcase or a purse, put your phone in your briefcase or your purse and sit down and talk with your client. Now, for us in the Second Circuit, everybody should want to come work in Aiken, all right? Grant standard issues all of us an iPad. Bang. Fresh. Jordan, there you go. Grant issues us all iPads. Our whole office is paperless, and that's actually why I'm going to be training you guys on how to use Defender Data. That's actually the hope of the commission at some point in the future, is that we're all fully utilizing all of the advantages that Defender Data offers, and that's because we pay a lot of money for it, and it's a fabulous, fabulous product, and we're going to talk about that later. But so when I go meet with my clients, I bring my iPad. You guys might have a laptop. Maybe you've got a pen and pad. I don't know. Everybody's got their own style. But when you're talking with your client, when you sit down at the jail, it's not like, hey, man, tell me how you did this crime, right? You want to get to know them a little bit. Ask them a little bit about their work history, whether or not they've served in the military. Sometimes we know that in advance because we've got a veterans treatment court, and so we screen folks as they're coming into the jail as to whether or not they would qualify for veteran services. But ask them about it. Ask about their education level. I often ask them, hey, have you ever been in trouble before? Because I want to know, I'm going to get their rap eventually, right? But I want to kind of know what I'm working with here. You got somebody who, looks to be, let's say they're 20 years old and they've got a drug charge. Well, I want to know if this is the first time they've ever been in trouble for drugs before, right? Or if they're like, nah, I know they charged me with PWID first, but I got 2 prior traffickings. You're like, ooh, we got a heavy hitter coming up on us then when you get indicted, right? Like I try to get to know a little bit as best I can, sort of what's going on with them and if they've ever had any interaction with the criminal justice system. And part of the reason for that too is it changes sort of the tenor of our conversation. Somebody who's never had any interaction with the criminal justice system typically is a lot more scared, knows significantly less right or wrong, and is going to need a lot more hand-holding. If I've got a client that's been in trouble, every decade for the last 40 years, been in and out of jails and prisons, like my tenor with them can be like they know what's up. If this is like their 3rd trafficking, it's like, hey, show's up, the mule's over, it's over. Let's talk about it, and we'll work through it. You always want to talk to them about what their biggest concern is. Everybody's got something different. Right? Like the mom who wants their kid home for Thanksgiving. Well, maybe the kid don't want to go home for Thanksgiving, right? Their biggest concern might be like, gosh, I'm going to lose my job. Where we are in Aiken, we have the Savannah River site, which is a Department of Energy. I guess there's a whole plant there for nuclear power. And essentially, a lot of people, when they're charged and they lose their job out at the site, what they're worried about is their security clearances. Right? Like you can get charged with possession of marijuana going into the Savannah River site and they can take your clearance from you. All right? Or more often what we see is they get charged with like having fake pee on them because they've been smoking marijuana. Right? And those sorts of things might be what their biggest concern is. So finding ways and avenues to process them through diversionary programs where they can keep their clearances. Maybe it's collateral consequences. I think the biggest one that we see in, correct me if I'm wrong, I want my guns. They can't take my guns. No, can't do that, right? So explaining to them based on their charge, like, hey, these are the collateral consequences of where we are. We're going to get your discovery. We're going to go over that. I always tell them, hey, look, my commitment to you is this. You will see me at least once every 30 days for the entire time that you're incarcerated. If there is a reason that you won't, I will tell you in advance. So like when Ian and I were getting ready to be in trial, I told all my clients in the jail, I went and saw them before the trial happened, hey look, I'm being trial. The week before trial, I prep for trial, that's all I do. The week of trial, that's all I do. All right, I'll see you guys as soon as the trial is done as quickly as humanly possible. All right, and I let them know it in advance, right? I also let them know, hey look, when I get your discovery, I'm going to come out and I'm going to read it with you. We're going to spend time talking about what it says. We're going to spend time going over the facts of your case. We're going to spend time talking about how does this stuff actually, your facts apply to the law in this case, okay? And so just giving them proper expectations, I think, as a lawyer is really important so that they know, hey, I'm going to see you, okay? And B, you're going to come and you're going to deliver on these promises. And then as you do that over and over and over again, your client will trust you more and more. And you know, I'm gonna just say this, maybe I shouldn't, but here's the deal, okay? Guys, as public defenders, you're going to have more face time with clients than any private lawyer could ever have. And if you ever leave the public defender's office and you go into private practice, you better believe that your reputation and the work that you did while you were a public defender follows you. The jail talks like the streets talk, right? You know, we all have, maybe you don't, I can just say there's folks in our area we know, hey, those folks did great work when they were public defenders and frankly when they were solicitors, and when they went into private practice, they're doing great. They're doing really well. And then there's folks who had a tendency not to communicate with their clients and not to really do what they were supposed to do, or didn't quite follow through on the stuff they saw. And the private practice is sort of a reflection of that. Okay? So just keep in mind, maybe you want to be a public defender for the rest of your life. I hope you do. But if you don't, just know that your time now matters for the future. It's like I saw this cool quote about Usain Bolt where he's made $119 million running a total of 115 seconds. Whoa, right? That's pretty sweet. Yeah, but see, when you think about that, what you have to also remember was the 20 years of training and development and investment that he put into himself, making no money, doing nothing, that led to those big results later, right? So, it's just important that the work that you're doing now will ultimately pay off, and it all starts with your clients. Because the best, truly still, I know people love the Google and the TikTok and all that stuff for getting clients. Your best source of getting clients is word of mouth. If clients like you, if clients respect you, if clients believe that the work that you do is good work, they will refer people to you. Just really how it works, right? And see, and it's not just with your clients, but see, once you've established yourself as a person who cares about their clients, you've delivered on your promises, you talk to them, you're honest with them. I think Alicia was talking about like just being honest with them, like telling them the truth, like, ugh, we are in trouble, Barney Rubble, when we're in trouble, right? You just tell them, yo, we're in trouble. Because those things, not only do they impact your current client, but then your clients in the jail are going to start talking to other people. Like, hey, Bush is going to tell you the truth now. It might hurt. Jordan's going to tell you the truth. It might hurt. Logan's not going to talk about his client interactions with anybody. Yeah, so you can have whatever type of interaction you want with Logan. He ain't going to talk about it ever, right? But the jail's going to talk about these things, okay? And your clients are going to talk about these things, and so it's important. Again, it's your reputation. Nobody earns it for you. Nobody can sell you, right? It's you. Your reputation, your hard work, and your clients are going to talk about it with each other. Also in that first meeting, you kind of want to, explain to them the dangers of changing their story later. As Ian and I found out last Thursday. Sometimes you get told this story and you're like, hey, that doesn't sound like all that. Like, where was Alicia like, hey, maybe you just bonked that kid accidentally into that glass door, okay, that's fine. And then you get the discovery and there's like a shattered glass door and there's blood all over the floor and a screaming child when law enforcement shows up on body-worn camera. I guess that bonk was a little more than a bonk, right? So you got to explain to your client, like, hey, when you're talking to me, all right, just understand that the story that you tell me, I'm somewhat bound to, and if you lie to me, right, or you tell me you are going to lie, there's consequences. You don't have to explain to them right then and there, like, what the consequences are, but all of us know what that is. And have y'all ever been in that situation? Don't raise your hand. So you just kind of tell them, and you can say, hey, look, I want to talk to you generally, like tell me about like the times and the dates around this stuff. If your client has a very, very, very specific defense, that's probably in the first meeting where I get real specific. If they're like, hey, I know they said that I threw that kid through the sliding glass door at 11 p.m. on yesterday, but dude, I was at the plant working, and I worked from 7 p.m. to 7 a.m. Well, that's something real specific I want to know up front and in advance so that I can go and immediately get to work on subpoenaing your work records and getting this stuff cranking so that I kind of know, hey, is this story true, number one? And two, Can I prove it? Because if I can, I can get you out of jail really quick. You know, you want to talk to them about what they're charged with. You want to talk to them about what their potential sentences are. I'm sure all of you have sat in a courtroom and the judge is going to ask the lawyer, or ask your client, has your lawyer advised you of your charges and the possible sentences that it carries? And, the client says, yes, Your Honor, or whatever. But telling them up front sort of what their stuff carries and what they're looking at. And don't be ashamed to look stuff up. Some people are I've seen it where they're like, oh, it's this, this, and this. They want to like talk off the top of their head and they're actually wrong. Like, don't do that. Just say, you know what? This is what you're charged with. I know what you're charged with. Let's look up the sentencing range together and I'll actually read you the statute, right? That's an easy way of saying like, hey, I don't know what it carries. Like somebody says, hey, Jordan, what does CSC first carry? Right, I don't know. I don't know what it carries, but what I do know is that it's in South Carolina Code 16. I can look it up. We'll look it up together. We can read the statute, and the statute's going to tell us what the penalty is. And then I'll show you later. You copy and paste that stuff into your defender data file, so it's there always and forever anytime your client asks you about it later on down the road. But kind of giving them an idea of what they're looking at, because sort of like Alicia was saying earlier, you'll have this client who's out, got charged in 2021 with trafficking meth, and then got out on bond and got charged with Berg first in 2023, but it was kind of like a crummy Berg first. So like they got out on bond again, and now they're charged with murder, and they've been in there for 10 days, and they're like, oh man, I need a bond like yesterday. And you're like, oh man, rats. Under the new bond law, all your bonds are about to get revoked. So your tote's not getting a bond. Happy to file this motion. No problem. Tote's not happening for you. And all your other bonds are getting revoked. Oh, bummer, you're also not entitled to credit for the time that you're serving on the prior 2 violent offenses. So if I do that and they revoke your bonds, you're not getting credit on any of these things. Your choice. Yes, tote's your choice. Unlike Alicia, I'm always down to tell a client when they're acting like a fool. I got no problem. If I think somebody's acting like a fool, I'm like, hey, look, you're a grown adult. All right, you get to make your own decisions, but the decision you are about to make is very foolish. Very foolish. And if you want to make a foolish decision, I'm your guy. I'm ready to ride. Let's do it. Let's go. But if you want to know, because I don't ever do that like, oh, Mr. Bush, if you were me, what would you do? I'm not you. I don't have the same family background that you do. I don't have the same life influences that you do. I don't have the same pressures maybe from the outside that you do. In this particular situation, I'll just tell you what I think is wise and what's foolish. And you can do with that what you want. And you can PCR me on it later, which they do, and I'm happy to sit up there. Yeah. Very, very foolish for my client to go to trial after his mama saw his smiling mug and said, yeah, that's him on the video, punching that kid in the face and stealing a PS5. No problem saying that in a PCR, right? Any of y'all been in a PCR hearing before? No, not yet. That day will come. PCRs are great where essentially your client is saying that you were ineffective in your assistance of counsel, and we're going to talk about why taking really good notes in defender data can help you defend yourself when you go to PCRs later. But ultimately, as long as you've explained all of that, and Grant put up here the trial penalty. Let me tell you something. I don't believe in trial penalties. Ian was actually with me. I heard Judge Young give the best explanation. Who knows who Judge Roger Young is? Raise your hand. Y'all from Chucktown?
Yes, sir.
Man, that's where I was born and raised. Chucktown. Got a lot of love for it. Also got a lot of love for Judge Roger Young. Judge Roger Young said this to us on Monday before we started our trial. He said, hey, look, guys, right now you can go tell your client you control the flow of information. You and the prosecutor are going to tell me what you tell me. If it's a plea, I'm going to hear that. I'm going to make a decision based on the information that you give me. And a lot of people believe that there's such thing as a trial penalty. Judge Young would tell you that doesn't exist for him. Now, some judges, there might be a trial penalty, but Judge Young says it doesn't exist for him. And what he says is, hey, look, as trials go on, I tend to hear more and more and more egregious information that wouldn't come out during a plea. And typically, not always, typically that more and more egregious information is against your client. And that's typically why the sentences are worse at the end of a trial than they are at a plea. Now, maybe you've been in like a plea where like the solicitor's like laying it on thick and basically trying your case. Like, yeah, okay, so there's outliers here, right? But I don't really ever talk to them about trial penalties in the first meeting. I don't know why, honestly, Grant does, because I've never watched him do this presentation. So I don't talk to them about that. I don't necessarily think that's overly important in the first meeting. That's going to come later as the case is kind of moving along and looking like it's going to ultimately resolve. But if they ask you, sometimes people ask, "Oh, is there such thing as a trial tax?" Like, you can explain it however you want. Pay close attention, Jordan. Eye contact, care about them. Who knows what actively listening is? Who's behind you? What's your name?
Caroline,
Caroline, what's active listening?
it's listening to somebody without thinking about what your response is going to be, actually listening to them.
And that is so hard to do as a lawyer, right? Aren't you trained, like you're trained in law school, to be talking with a professor, and a professor's like asking you questions, and you're like anticipating what next, right? Or you're in a preliminary hearing, and the officer's like giving you this like awesome bit of information, and you're like, whoa, like a shark into blood in the water. You're on it. You're ready for the next thing. And oftentimes when you turn off your active listening, you miss things. You're going to find that the best, maybe you guys have seen some awesome trials, I don't know, but I'll tell you, and I know, Chris, you've seen some trials doing what you did prior to being a public defender. The best cross-examining lawyers are lawyers who actively listen. They actively listen on direct examination. They actively listen to the responses that they receive on cross-examination. Because you might be crossing somebody and thinking like, oh, you did this, didn't you? And you did this. And they're like, no. And they're like, and then you killed him. They're like, yes, I did. And they're like, and you did that. You just skip right over it, right? Because you're not paying attention. You're so caught up in the questions that you want to ask that witness. Well, when you meet with your client, it's basically the same thing. Just listen to them. Respond to their responses. They might give you some really good information about their case that they didn't even know was of value, right? Maybe they don't watch CSI, right? And they don't know about what an alibi is. Or they don't think that what they're going to tell you is an alibi. Like, hey, I know that they said that this thing happened at 6 p.m. at the car wash, but I just want you to know, like, I was at work at 7 o'clock. Okay, well, let's talk about that. Why is that important? Well, how far is your work from this car wash? How far is this car wash from your home? What type of attire do you have to wear when you go into work? Like, you can take little threads of information, beneficial information, and it may not be, it may be nothing, but it gives you opportunities to go and seek out ways to better defend your clients. We talked about who we can speak with. The roles of attorneys and clients is, look, I tell everybody, you're a grown adult. Who does juveniles? Yeah, y'all do juveniles? Yeah, praise God for you guys. Thank you. That's awesome work. I don't deal with kids, okay? I do nothing but adults. All right, so what I'm about to say is only for the adults. In juveniles, you got to be a little bit more tender, a little bit more engaged with what's going on with the family. Now, if y'all met Kelly Perkins Brown, who is the bomb.com juvenile defender in the Second Circuit, been juvenile defender, public defender of the year, she's the bomb, all right? If y'all met Kelly Brown ain't going to fool around with no juvenile. She's going to tell them how it is, when it is, whatever. But y'all do you for your juvenile clients. For adults, I tell them, look, man, you're a grown adult, all right? I ain't here to tell you what to do. I'm not here to tell you how to live your life. I'm here to serve you, okay, as best I can, and I'm here to help you if you want help, right? Let's talk about drug clients because that's the easiest one to talk about, right? You got a client that's been on drugs. I got a great story. I got a client who had been on drugs literally since she was 9 years old, okay? Her rap sheet from New York, Florida, and South Carolina was 47 pages long. She had been convicted almost every year of a drug charge for the last 20 years, okay? Yikes. That's bad news, Bears. Nice as can be. You start talking to her about her childhood. Her mom was actually pimping her out for drugs when she was 9 years old, which is how she started using drugs with the guys who were having sex with her while she was a child, right? She got addicted to those drugs and as a result of that lived a life of crime and poverty, and really frankly because she had no help or hope in any facet of her life at all. And now she's with me, and she's looking at a trafficking third, and it's mandatory time, and we're talking, she's like, Mr. Bush, like, all I want to do is get help. I'm just tired. I've been doing this for so long. I've never had a real job. I've never lived like a real life. Like I'm done. And I went to the prosecutor, and the prosecutor, who is now in private practice and a contract public defender, is a good man, but was like, nah, I'll plead you down to a lesser charge, like, but I can't send her to rehab. Sorry. And so we go into court. He gives us the opportunity to kind of plead straight up, and we get some. She got some time. And then she was released to go to a rehab on her own after she got out of prison. Ultimately, she had made that choice. We connected her with some resources while she was incarcerated, and while she was in prison, she then got in touch with people at the Oxford House. And maybe many of you guys know what that is, but ultimately she gets released from prison directly to the Oxford House. She had nothing to her name. No clothes, no money, no nothing. And now she's a regional director for the Oxford House. She spoke this past year at the national convention, right? Like, what she needed was to get out of the lifestyle that she had lived for a really long time, and I couldn't help her do that. Right? I could give her resources based on her charges. I couldn't make the prosecutor see what I saw. And frankly, I couldn't have imagined how well she would do as she has done. Right? But I tell them all the time, like, hey, I am here to help you if you want help, particularly with drug folks. They say you can't be a therapist or a cheerleader. I would say this. I am definitely not a family counselor. Okay? I tell people I don't practice family law. Appreciate it. Like, if you need to know about what's going on between you and your wife and why she ain't answering your phone calls at the jail, that ain't me. And no, I will not ask your wife why she ain't answering your calls, because I don't care what the answer is, okay? But what you can do is encourage your clients. And I try really hard to encourage clients to the best of my ability and to the best of their willingness to accept it, to move forward in positive directions in their life, whatever that might look like. And that's by bringing options to the table. Like, hey, yeah, you're charged, you've never been in trouble before. Why don't we try to go get you a PR bond, and then let's talk about PTI. That's an easy diversionary program. Let's try to kick you through that. You can get some drug counseling. I think that'll be really good. And it's a way for your charge to get dismissed and for it to be expunged off your record. And if you tell me, oftentimes, like, y'all find, dude, you're gonna, that's Totes crushed Tylenol. That's not cocaine. I don't do cocaine. Okay, all right. Well, hey, that's fine. Let's wait till the drug results happen, and when the drug results come in, then we'll talk about what we're gonna do with your case. All right. Preliminary hearings. Everybody wants a preliminary hearing. How many of you have had a client request a preliminary hearing? Yeah, everybody. Man, I love a prelim. I love a good prelim. Ask Ian, or really ask Grant. Grant would tell you he can't believe how many prelims that I hold. But much like Usain Bolt, who ran for 20 years before he made $119 million off 115 seconds, prelims are your arena to practice your cross-examinations. It's going to be the most important part of any trial that you do 9 out of 10 times, unless your client's testifying. And having a preliminary hearing is a great way. I hold prelims for a number of reasons. Number one, I hold a prelim because I don't think that the state can prove their case and I can't get the prosecutor to dismiss it. So I go in front of a judge and ask the judge to do it. Number two, I don't have drug results. And for whatever reason, in our circuit, you can hold a prelim and magically they show up. Number three, sometimes you got a client charged with something real bad and something real, and they're like, man, they ain't got nothing on me. No. They got nothing. I totes didn't confess to them, even though I kind of told them my baby did it. They got nothing on me. And then you go and you have a prelim, and you got an investigating officer like, yeah, and Ian did this, and Ian did that. And then we talked to Jordan, and Jordan said Ian was bragging about killing him. And then we talked to Logan, who doesn't talk about anything, so he wasn't helpful. And then we talked to Catherine, who said, Ian totes did it. And then we went and we talked with Gabe, and Gabe was like, yeah, I kind of saw Ian in that area about 10 minutes before it happened. And then your client's like, man, all that sounded pretty bad. And you're like, bro, I've been trying to tell you it's better in this prelim than in an open trial, right? And then sometimes I hold prelims because honestly I have no idea what's going on in the case. I don't know, maybe you've had this, you've got a client that's charged with something serious. I had a murder case where I literally got 2 pages of an incident report for the first 6 months that I represent. I'm like, what is happening in this case? And then you go and you have a prelim, and they're like, oh, well, I just so happen to have this huge supplemental report here that I wrote up right before you wrote up, right? And then you get like the rest of your discovery. And so I think they're important. I hold a whole bunch of them. I request them in lots of cases for lots of different reasons. If it's reasonable to waive it after I've requested it, I waive it. If we get the discovery and it becomes there's really no issue here, I'll waive them. But particularly when clients are in jail, they really care about prelims because everybody's talking about it. Like, hey, man, I filed that prelim paperwork. Can't wait to get it, man. Can't wait to get it. How far are we away? We getting that next week? Or, they're going to hold it in like 10 days, right? Well, like in our circuit, there's like a 6 to 9 month backlog on those. So it's like, yeah, it's going to be a while. But we'll have it when it's had. Talking about bond issues, obviously you're going to want to talk to your client about like, hey, what can you post for bond? What are you going to be able to do? If they've got a bond, who they're talking to try to post it. If there's special conditions on it, like DVs, sometimes there's no contact orders. Talking to them about complying with those things, especially, you come in for that initial visit and you're talking with them, and I give them the spiel, hey, you're going to see me at least once every 30 days. I'm like, hey, bro, I'm out Friday. I'm bonding out. Okay, that's great. Well, since I know that, let's talk a little bit about what your bond conditions are, and then immediately upon your release, you need to call my office and schedule an appointment to come in and talk to me about what's going on with your case, right? Jail issues. Explaining the dangers of communicating over the phone. A solicitor's best friend in trial is your client's jail phone calls. If you guys haven't tried a general sessions court case yet, you will. And once you do that, you will find that your client says the dumbest crap ever on jail phones. All of our cards tell them, please, please, for the love of all that is holy, do not talk about your case on the jail phones. I don't care if your baby mama really wants to know the facts of your case, or your mom's telling you she loves you so much and please just confess to her that you killed this person. Do not talk about your facts of your case on the phone. You might also want to add in there, like, don't rap about it either. Just throwing that out there for whoever that might be. Maybe just tell them don't rap about it. Maybe if you are a famed poet, some of my clients like to believe that they are famed poets, maybe like the famed Young Jeezy. I would say to you, please don't write your raps down. Just keep them in your head, right? Because all that information can eventually get taken from you and turned over to the state. And when you're like, oh yeah, I killed everybody, I did it, it was me, it was awesome, and they're gonna let me free. Well, no, they're not. No, they're not, when that gets played to the jury. So please don't do that. Explaining the perils of jailhouse legal advice, y'all probably all know what jailhouse lawyers are. I don't need to tell you about that. Just, hey man, don't believe everything you hear in there. People will be like, oh man, I heard Gabe's the best lawyer in the world. And if I was Gabe, I would be like, hey, I appreciate the compliment. That's real kind. You can judge for yourself. Don't believe everything you hear up in here. All right, because you're going to hear all kinds of stuff. And probably more than half of it's totally untrue. So don't believe everything that you hear. Explain, discovery and sort of how that works and why it's dangerous to have it in the jail. Quick story. My very first case ever that I tried was a murder case, and our client wanted his discovery in the jail. He said, "Give it to me now," and we sent it, and so he got it. And then the star witness in that trial got on the witness stand and said, for the state, from the jail, said, oh man, Derek's client was totes bragging about this in CPOD. Oh man, he killed a 16-year-old girl. It was crazy. He was bragging about it. He was rapping about it. Here's some other stuff, boom, boom, boom. And our guy gets convicted. He goes to prison for 50 years, and about 2 weeks later, the state's witness, jailhouse snitch, goes and pleads to armed robbery and gets lit up. Woo! Judge Early lit him up. He got 22 years. Just got smoked. And he was thinking like, hey, I'm getting my 10, right? I cooperated with the state. I did my thing. Hey, Tisa. I cooperated with the state. I did my thing, whatever. Dude got smoked. And on his way out the courtroom, he says, Bush, I need to talk to you. Yeah, he ain't represented anymore. He just pled guilty. What's up? He says, hey, I need to tell you, everything that happened in that trial 2 weeks ago, yeah, that was a lie. I was like, excuse me? He's like, so your client was in the shower and his pod door was open, and I went in there and I read his discovery, and I went to my lawyer and said, hey, I got information for you about this case. And I asked him if he thought it would be helpful. He told me it would be. And so I offered to meet with the state. Your client never said any of that stuff to me. I said, now you do realize that you're telling me you committed perjury, right? Yeah, I understand. All right, well, I'm going to go get an investigator, and we're going to come back here and we're going to talk to you. And then we're going to file a motion for a new trial, for our client, which got denied, mind you. Crazy to me, but still got denied. Anyways, but those things happen, right? Like people steal discovery, people will read stuff, and people, look, if you're in a deep hole and you're charged with armed robbery and you totes know you did armed robbery and you want to get the best deal possible, what do? You help the state. That's a shocker, right? So, you just need to explain to your client, hey, there's perils of having your discovery in the jail. Just be careful with it. Mental health issues, we deal with this on the front end. We also have a mental health treatment court. And mental health, we screen all of the folks when they're applying for public defenders for mental health issues. But if you don't do that, if your circuit doesn't do that, make sure you're talking to your clients about any mental health issues that they have. I'll brag, we really do have like the best mental health care, frankly, in the entire state in our circuit. We're one of the pilot programs for the Department of Mental Health. We do all kinds of work with mental health. I'm happy to talk to you about that outside of this. Feel free to call me or to talk with me while I'm here today. But it's really important to know what's going on with your client, because if competency is an issue for your client, you have to get them evaluated by the Department of Mental Health, and the Department of Mental Health will not evaluate your client unless they have all of their records. So you need to know where their records are, where they've been treated, and you need to know when, as best you can, to request them. Now, oftentimes folks who are really mentally ill are poor narrators of their own story, especially if they're unmedicated. And so that also kind of plays into family dynamics. If they've got good family connections, they can really help you get where that is. Conflicts, please don't be a lawyer who conflicts every case that ever comes to you. There are going to be cases that are certainly conflicts, co-defendants. Your office really should be doing a pretty good job of that in the screening and assigning of cases, I would think. I know they do where we are, but just make sure that that's something you talk about with them. And then the back investigation. I don't know if every circuit has an investigator or multiple investigators. We do. I have an investigator that's assigned to me. And so if I know this case is going to require some investigation, I tell them up front, hey, look, Wayne Martin's my investigator. He's the best investigator in South Carolina. He's the bomb.com. He's my right-hand man, and he's going to be coming to see you. So when a guy who comes up here country as corn with no hair on his head wants to talk to you, you talk to him. Otherwise, you don't talk to nobody unless I'm in the room, right? And so, you kind of let them know, hey, this is what's going on with that. Everybody wants to file a speedy trial motion. I'm not going to get into that. Don't file, please, for the love of all that is holy, do not file a speedy trial motion until you have all of your discovery. Okay, Supreme Court said that in their docketing order. You need to have all your discovery. Discovery actually has to be complete, allegedly. When a solicitor puts your case on the trial docket, I have yet to be in a trial since that order came out where I didn't get discovery like 3 days before the trial started, or what have you. But allegedly, they're working on that. He talks about here irreconcilable differences and complaints to supervisors or letters to Lawrence. Look, guys, if you're communicating with your clients, all right, and you're treating them with dignity and respect, and you're really actually client-focused in the work that you're going to do, you ain't going to have to worry about much of this. Okay? Yeah, every now and again you're going to get a letter to ODC because some jailhouse lawyer told them, man, this is the best way to get you a bond. Just write ODC and tell them how terrible your lawyer is. You're going to get in court before that 6 months, and then you can tell that judge, hey, my lawyer's all right, but what I really want is a bond. And then that judge is going to be like, no bond for you, and your lawyer is going to stay on your case. But anytime they make complaints or grievances, document your file. If they make, at any point, they tell you, I want you to file a motion, I want a new lawyer, I'm done with you. Well, you're obligated, you're ethically obligated to file that motion. In our office, it's our practice, we just let our boss know, hey boss, this guy said he totes wants to fire me. I'm filing this motion, I'll be ready to defend myself. Again, I take a lot of pride, sort of like I told y'all at the beginning, I take a lot of pride in the work that I do and the work product, so I'm not afraid to defend myself in front of a client ever. Client's like, oh man, Bush hasn't done nothing. He never comes to see me. He didn't do any investigation. He didn't do anything. Later when we go through defender data, I'm going to show you how. I just pull it right up. Well, actually, Judge, this guy's been in jail for 9 months. I've seen him in the jail 11 times. My investigator was contacted on our first meeting. I've met with him 3 times since then. We've been out to the incident location once already. I've talked to his grandma 5 times, his mom 3 times, his brother too many times to count, and I'm not sure which one is actually his girlfriend, but I've talked to 3 of them. Logan hasn't talked to anybody because he don't talk to nobody about his client experiences. But right, like you can defend yourself. Go ahead.
Sorry to interrupt.
No. This is, hey, perfect.
Whenever I get a request for motion relief, I file it.
Yeah.
But though I take copious notes to the detriment of any attorney that takes my case after me.
Yeah, that's good.
At those hearings, our judges in Richland tend to take control over it,
Yeah.
and not talk or ask us anything.
That's fine.
What's going on in this case? Thank you, everybody leave. What's your problem in this case? And then the judge decides whether they're going to try to say, no, actually, I doubt your attorney did anything you just said, but I'm going to coax you into reconsidering before you have to restart your entire case. Or the judge goes, I think you're a jerk, and if that's what you want, let's do it right now. So I take a back seat. Would you suggest I change that, or am I good doing what I'm doing?
That's the talk you need to have with your circuit defender. So in our circuit, we defend ourselves, all right? And I'm not going to let my client get up there and say I'm a crummy lawyer, I ain't doing my job, I ain't coming to see him, I don't ever answer the phone when they call. Like, I'm going to stand up for me. Okay? That's how we do it in Aiken. Y'all can do it, within reason, whatever your circuit defender says. But I mean, when somebody's calling into my integrity into question, yeah, I'm going to defend myself. For sure. But again, if your boss doesn't want you doing that, hey, keep your job. You know what I mean? Don't be. But yeah, we defend ourselves. Yeah, I defend myself to the court. Well, typically to my boss first, to the court, and then if ODC ever writes me, man, I love a good ODC complaint because I serve my answer on my client.
Oh yeah.
Oh yeah, and it's long. Yeah, voluminous. I'll attack everything that they say I did wrong or every little code of ethics that they think that I violated, and I go through them one by one, and I tell them exactly how, A, I haven't done that, and B, how I've been doing a good job for them as their lawyer. I'm also not too proud to admit when I've been wrong. Again, y'all get the opportunity after you try cases to sit down and do a PCR. I've been on the witness stand, and they're like, hey, don't you think that you should have actually, this was one of my first cases, don't you think you should have actually gone into the apartment where all this craziness happened? I'm like, yeah, I should have. There was new people who lived there that wouldn't let us in, but I probably could have talked to management or something. I wasn't advanced enough. I didn't think about it. I was just like, oh, they won't let me in. Okay, I'll just look at a blueprint of what this place looks like. And so, it's okay to admit when you're wrong. I'm not saying go up there and say youthebomb.com when you've been doing a crappy job. Don't do that. Because again, your integrity is at stake, right? And judges, to your point, judges, especially when they're your resident judges, they're your local judges, man, they know. They know when a lawyer is doing a good job and is a good lawyer and cares about their clients and is arguing effectively and advocating well for their clients and tries good cases, right? And they know when somebody's a crappy lawyer. They just know. And so maybe you don't have to defend them for that particular reason. They know you do an excellent job. And they're like, yeah, I know he's doing a good job and all this stuff is crap. But it sounds like, what's your name?
James Johnson.
Sounds like James don't want that guy as a client. I wouldn't want him either. So we'll kick it, right? But if your judges know you're doing a good job, you'll be fine. Yeah, they know. And Kat Hudgens is about to talk to you guys about photo lineups, and this is holistic defense, and she starts in 1 minute, so I'm going to tell you this. Basically, everything that I've just talked to you about is holistically representing your client. I'll be glad to talk to you offline about why helping folks with drug addictions or folks who have past traumas and why all that, or mental illnesses, why all that's really important, and to keep that in the forefront of your mind as you're processing through their case. But we don't have time to do that. So appreciate y'all's interaction and time. I'll be back in a couple of minutes actually doing defender data with Ms. Tisa, but I don't want to run late. I want to keep us on schedule.